innocence play part when you enforce the sentence that you are questioning, was it violated or not?
He says he is harmless. He says he never escaped.
Accused of escaping, but that accusation has been implemented already by correctional services. So the point is, why am I going to a criminal trial where I'm already guilty of a crime that I'm supposed to go and defend myself? Because even if I defend myself and I can showcase that, and I side to say this, that there is more than overwhelming evidence that I have and my legal defense has, that we are 100% sure I would never be in a position where I'm found guilty on escape. Because the escape is not a typical escape where a person broke out of a wall and jumped, Your Honor. It's a situation where somebody has been out for a very long time.
But this is the same man who allegedly faked his own death, fooled an entire prison, and disappeared without a trace. Today, Thabo Bester was back in court, making claims that are leaving South Africans divided. Is he telling the truth, or is this just another move in a long, calculated game? Stay with me, because this story gets even more unbelievable.
I don't challenge my sentence. I challenge that a person can be free and correctional service can decide that this person escaped and enforce the warrant. And there's no one to do checks and balances if it's correct or not. That is at the heart of this application, nothing else. That is what I am asking. The classification of being a sentenced person, being a remand person, that is terms used by correctional services.
To understand what's happening now, we need to understand who we are dealing with. Thabo Bester is not an ordinary inmate. He is a convicted rapist and murderer, once locked away with no chance of freedom anytime soon. But in May 2022, everything changed. Inside a cell at Mangaung Correctional Centre, a fire broke out. After the flames died down, a body was found, burnt beyond recognition. Authorities believe it was Bester. Case closed. For months, South Africa believed Thabo Bester was dead, but something didn't add up. Questions started to grow. How did the fire start? Why were there inconsistencies in the investigation? Then came the truth. The body in the cell, it wasn't Bester. He was alive, and somehow he had walked out of prison. What followed felt like a movie plot. Investigations revealed that this wasn't just an escape, it was a carefully planned operation. Authorities believe he had helped, including celebrity doctor Nandipha Magudumana and even insiders within the prison system. A body was allegedly brought into the prison to fake his death. A fire was used to destroy evidence, and in the chaos, Bester vanished. But freedom didn't last forever. After a massive manhunt, Thabo Bester was eventually captured and brought back to South Africa. This time, there will be no mistakes. He was placed in a high-security facility in KwaZulu-Natal, far more secure, far more controlled. Authorities made one thing clear: this man would not escape again. Now, here's where things take a surprising turn. In court, Bester made bold claims. He says he is not dangerous, he is harmless, and most shocking of all, he says he did not escape.
And Your Honor, under category, they write here, escapee. They wrote escapee, but they accused me of escape. And they want me to prove, and they want to prove a case, but they already made a decision. That escape is a word. The basis of that is that you violated a warrant of sentence.
Yes, you heard that right. Despite everything, he denies escaping from prison. Instead, his legal team argues that he is being treated unfairly.
Escape is a terminology that is used by Correctional Services Act. It is not a terminology of law. The law interpretation of warrant violation is then understood by Correctional Services as escape. And the challenge here is, Your Honor, the challenge is the warrant that sits before this court. That sits before the respondents. Could it be violated, or could it be still valid? Now, this court is not supposed to answer that question. But the question the court's supposed to answer is, do they not infringe my right by titling me and treating me as an escapee prior to findings in the criminal court?
Bester also wants to be moved. Right now, he's being held in a supermax prison in KwaZulu-Natal, but he wants to go back to Gauteng. Why? His lawyer says it's difficult to prepare for trial when he is so far away. They need to review evidence, videos, images, documents in person. But the court had a different view. At the Gauteng High Court, the judge listened carefully and then responded.
And what makes a warrant valid and not valid? It is a criminal court to determine, because you would have to bring documentation, or they would have to bring evidence to say there's nothing as parole, there's nothing as presidential pardon, there's nothing of executive power that excluded, that said that this sentence is ended and Mr. Bester should be released. Now I say that it is my presumption of silence in the proceedings of criminal court under fair trial rights that I should not answer that. Your Honor, the counsel also misleads the court by saying that they do not ask me to furnish the court and demonstrate if I was released by pardon or other means. They clearly state that if I have any form of release officially, I should bring it forth. Now, the prison in question is a private prison. And in that private prison, I can tell you by the Correctional Service Act 116 states that National Commissioner, the Minister, and the President, these three people are the ones that could have made a decision.
Unfortunately, the judge said the transfer was legal. It was done for security reasons and Bester's rights were not violated. He also made something very clear. Modern technology allows virtual consultations. Lawyers can visit if needed. So the argument that Bester cannot prepare, the judge rejected it completely.
The accused or remand person has the right to defend himself and makes that determination. I am kept completely alone, by myself for 3 years, with no contact except legal visit and family visits that last for 1 hour and 30 minutes. Now, if you say that that conduct is correct and it does not trigger urgency.
Then came the final ruling. The application was dismissed. No urgency, no merit. And one powerful reason behind it all, Bester's past. A man accused of faking his death and escaping prison is not someone the system is willing to take lightly.
I escaped. There's nothing else that they argue. I'm not a violent person. I've hurt no one since I've been in prison, even when I was outside. The murder and rape are a different application in a different court. I don't want to deal with it now. But what I want this court to take note is that every single element that I've raised, why this application triggers urgency, is because of the conditions. And those conditions directly affects me. The point of 3 years of this application, Your Honor, a person cannot be kept in a place where you cannot access a court and you cannot access documentation. They've added complainant request in this application. The complainant request clearly states, there was a time I was requesting books. For 2.5 years, they never gave me books. So how could I have known that there was a violation?
So right now, Thabo Bester remains in one of the most secure prisons in the country, which is Ebongweni. Still denying everything, still claiming he's harmless. But the question is, do you believe him? Drop your thoughts in the comment section. Like if you want more real South African crime stories, and subscribe because this case is far from over. And this is True Crime with Nsuku's Folktale. See you on the next case.